Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Thank you. Good afternoon. We have one case on our docket this afternoon. Is 19-30029 Butler versus Porter. Mr. Bakke.
Good afternoon, and may it please the court.
I'm sorry, I called the wrong person. Mr. Rios?
I'm Mr. Bakke, Your Honor.
Okay, I got it. All right.
Thank you. My name is Wes Bakke with SMU's First Amendment Clinic, and I, along with my colleague, Evan Rios, represent the appellant, Max Ray Butler. The primary claims in this case arise under the First and Eighth Amendments. My colleague, Mr. Rios, will present argument on Mr. Butler's First Amendment claim, and I will be discussing why the district court erred in dismissing Mr. Butler's Eighth Amendment claims. We would like to reserve 4 minutes for rebuttal. On the Eighth Amendment claims, there are two reasons why this court should remand this matter to the district court. First, Mr. Butler plausibly pled a number of Eighth Amendment claims in his complaint. Second, even if the claims as pled were implausible, a district court may not dismiss a prisoner's complaint with prejudice and without leave to amend, surprises the prisoner of the deficiencies in the pleading, and then grants them the opportunity to cure. Mr. Butler's complaint raised two plausible Eighth Amendment claims. First, he alleged that prison staff inflicted unnecessary and wanton pain on inmates by forcing them to use cold showers. And second, he alleged that prison staff were deliberately indifferent to his medical needs. The cold showers claim is presented most clearly in Mr. Butler's second supplement to his complaint at ROA 107, and again restated in his fifth supplement at ROA 156. There, Mr. Butler goes into detail on how officers inflicted quote unquote personal corporal punishment on inmates by forcing them into the cold showers despite the availability of regular showers. The deliberate indifference claims are presented most clearly in the initial complaint at pages 32, 39, and 40.
Where did he reference the Eighth Amendment?
Your Honor, he did not reference the Eighth Amendment in his initial complaint, but the form complaint provided to him by the Bureau of Prisons specifically instructed him not to cite legal authority. And to the extent that anyone reading Mr. Butler's complaint could not have reasonably understood him to be alleging Eighth Amendment claims, and we think that he did, there's also the separate and independent error of the district court in denying his motion for leave to amend his complaint.
But it seemed like there was a lot of back and forth with the magistrate judge giving him opportunities, and he kept filing stuff. So it's not like he filed one complaint and they dismissed it and didn't let him amend. It was kind of a back and forth for a while, right? And so how many times do they have to do the back and forth?
Your Honor, Mr. Butler filed a number of supplements to his initial complaint, and the magistrate correctly construed those as part of the initial complaint itself. The one and only time in this case that Mr. Butler was granted leave to file an amended complaint was for the express limited purpose of identifying which defendants remained on his First Amendment retaliation claim. So while Mr. Butler did file a number of supplements to his complaint, he could have filed 100 supplements and it wouldn't have gotten him any closer to curing whatever undisclosed problems the magistrate judge saw in his Eighth Amendment claims when it dismissed them sua sponte.
Yeah, but the problem is if the magistrate judge doesn't know he's making an Eighth Amendment claim, then they cannot point out what the problem is. I mean, it's kind of a chicken and egg sort of thing, right?
Your Honor, we think that it's clear that he did make out an Eighth Amendment claim on the cold showers, for example. A number of sister circuits have recognized that similar factual allegations relating to cold showers do, in fact, give rise to a cognizable Eighth Amendment violation. And the deliberate indifference claims that he alleged in his complaint were also clear. He had reported all of these conditions to prison staff. They were aware of it, yet despite this awareness, they delayed or denied him treatment, causing him harm.
The facts are there, but when did he first say, I'm making this claim under the Eighth Amendment?
Your Honor, after the district court dismissed his non-retaliation claims, Mr. Butler filed a number of documents asserting that he thought he stated Eighth Amendment claims, that he intended to state Eighth Amendment claims, and that he was ready to file an amended complaint. That is presented most clearly at ROA 409 in his request for leave to amend his complaint. He also filed a second request for leave to amend his complaint at ROA 438, where he again talks about how he intended to state Eighth Amendment claims. These motions were improperly denied by the lower courts, however, Your Honor, on the ground that Mr. Butler had been afforded, quote, multiple opportunities to amend his complaint already, but that was simply incorrect. The one and only time that Mr. Butler was granted leave to file an amended complaint in this case was to identify which defendants remained on his First Amendment retaliation claim. Despite having raised these Eighth Amendment claims in his complaint, the district court's first and only acknowledgement of them was to state that they had already been dismissed in a prior order. That prior order purported to dismiss all of Mr. Butler's claims with prejudice apart from his First Amendment claim. But nowhere in that order did the magistrate judge or district court devote even a single word to analyzing Mr. Butler's Eighth Amendment claims. Since
I have a question. I know, and you can defer this to Mr. Rios if you need to. I know you all didn't supplementally brief this point, but it is a question before us, which is the appointment of counsel issue. Do you have any argument that he did preserve that since he didn't appeal it to the district judge?
Your Honor, as far as the motion for appointment of counsel is concerned, we're relying for that argument on what Mr. Butler briefed in his initial briefing to this court. However, we would argue that there were exceptional circumstances in this case and that the district court did in fact err in refusing to appoint counsel for him. He
Right, but the magistrate judge didn't appoint counsel, but where did he appeal that to the district judge or contest that to the district judge? And if you don't know, it's all right. I just wanted to see if you had anything to add on that, because the government has argued that he waived that. So I'm just asking about that.
Your Honor, I don't have that record site in front of me, so we would defer to what's stated in the initial briefs on that point.
Okay.
On the Eighth Amendment claims, we are asking this court to remand this matter to the district court to reinstate the Eighth Amendment claims and, as necessary, to apprise Mr. Butler with notice of the deficiencies in the claims and to provide him one opportunity to file an amended complaint. On remand, if permitted to file an amended complaint, Mr. Butler could allege more specific facts regarding the Eighth Amendment violations. We cite a number of examples of what he could plead on remand at footnote 6 of our supplemental opening brief. And again, while he was never apprised of the need to provide these additional details, on remand, he may well be able to craft a complaint that overcomes whatever undisclosed deficiencies the magistrate judge saw in his Eighth Amendment claims. To conclude, we respectfully ask this court to vacate the district court's dismissal order and to remand with instructions to apprise Mr. Butler of any deficiencies in his Eighth Amendment claims and to give him the chance to file an amended pleading. Thank you, and I'll turn it over to Mr. Rios to present the First Amendment claim.
Your Honor, and may it please the court. My name is Evan Rios, and I too am with the SMU Law First Amendment Clinic representing Mr. Butler in this matter. I'll be addressing the second issue before this court, whether the Bivens Doctrine should extend to Mr. Butler's First Amendment retaliation claims. It should, and as a result, the court should reverse the district court's erroneous dismissal of Mr. Butler's Bivens action. Because of unique procedural and factual circumstances, this case presents the court with the opportunity to recognize a Bivens remedy in a new context without opening the floodgates to all First Amendment Bivens claims. Specifically, as was alleged at the district court and taken as true for purposes of this appeal, Mr. Butler was subjected to a years-long retaliation campaign for exercising his right to file grievances against BOP officers. Declining to recognize a remedy for the plaintiff here may create a ripple effect where prisoners are discouraged from invoking the grievance processes afforded them. And further, this may signal to federal jailers that it's open season to retaliate against prisoners who file grievances against them, knowing that without Bivens, the only remedy is itself to file more grievances, perpetuating a vicious cycle of retaliation. In light of this, extending—
Why isn't this something Congress should address rather than us? We are simply judges who apply the law. Why should we be creating law on this?
Your Honor, I recognize the concern about separation of powers, and I recognize the concern potentially about over-deterrence. But to quote Professor Steve Vladeck, the fact that Congress could address this is hardly proof that only Congress can address this. And part of the argument that the district court relied on in addressing the special factors here, Your Honor, is that the Prison Litigation Reform Act, the PLRA, itself counsels hesitation against extending Bivens in this instance due to separation of powers concerns. But the district court erred when it incorrectly relied on the PLRA's failure to create a standalone damages remedy as proof that no remedy exists at all here. And there are two reasons for that. First, Congress did not have a need to create such a remedy, given that the Supreme Court has recognized, especially in Carlson as it applies here, that there is a remedy that can be inferred directly from the Constitution. It's axiomatic that Congress legislates against the backdrop of existing law. And so the PLRA was passed some 25 years after the Supreme Court recognized the Bivens remedy and 16 years after Carlson was decided. So Congress's failure to create a standalone remedy here is hardly remarkable, knowing again that this a cause of action inferred by the Supreme Court based on the Constitution was there already.
Do you agree this, if we were to rule in Mr. Butler's favor, that would be an expansion of Bivens, it would not be just following Bivens or Carlson?
Certainly, Your Honor. And as we've conceded on page 50 of our supplemental briefing, this is a new Bivens context.
Okay, so then it gets back to, I mean, if we just said, well, we don't ever have to just defer to Congress, and we could just be creating laws right and left, and that seems completely inconsistent with separation of powers and the limited jurisdiction of federal courts in general.
Certainly, Your Honor, and recognizing that that's a concern that's been discussed at length in most recent Bivens cases. Again, Congress could act, but the fact that they could is not proof that only Congress could act. I believe that the judicial branch, as a co-equal branch of government, has the opportunity to act as a check on rogue executive officers, which I believe Justice Kennedy referred to in the Abbasi opinion as the core purpose of the Bivens doctrine. And beyond the PLRA, there are two quick special factors I'd like to get to that the district court discussed. The first was the increased costs of recognizing a new Bivens remedy here. And while it's true that recognizing any new Bivens remedy will, at the margins, increase litigation costs, if this itself were enough to counsel hesitation in expanding Bivens to a new context, there would be no point to have the special factors analysis. Courts would just see new context, and then they would decide that Bivens should not be expanded. But as we know, based on recent jurisprudence, the analysis is always two steps. And finally, just to address the cost issue and the early disposition of the Bivens remedy, qualified immunity creates a powerful protection for BOP officials undertaking a good faith effort to police prisons. This allows courts to dismiss actions on the pleadings and at the summary judgment stage. The last special factor that the district court looked to was the effect that this may have on BOP officials exercising their duties. But recognizing a Bivens remedy here in light of the specific facts that Mr. Butler alleges does not implicate the sort of quick heat of the moment decisions that both the defendants and the district court were concerned about. Mr. Butler was subjected to a years-long retaliation campaign for the exercise of his constitutional rights. And the Bivens remedy itself, again, as Justice Kennedy recognized in Abbasi, that is the core purpose of the doctrine itself. Now, pivoting quickly to alternative remedies, we'll rest on our briefing for the majority of the points there, but I just wanted to point out a few quick things. The court in Abbasi stated that the existence of an alternative remedial structure may counsel against the creation of a new Bivens cause of action. But here, it is very likely that there were not alternative remedies available to Mr. Butler. The district court specifically looked at the BOP's Administrative Relief Program, or the ARP, but it's absolutely essential to note that Mr. Butler did attempt to participate in the ARP in pages 44 through 47 of the record, and it was this action itself that caused the retaliation that Mr. Butler is alleging. Federal officers cannot obstruct a prisoner's access to a grievance process or procedure and then invoke the availability of that process itself as proof that no claim of action exists at all. And then one more quick point about the ARP. The ARP is not Congress's design, it's the Bureau of Prisons' design. The court in Abbasi noted that the touchstone of the Bivens analysis is statutory intent, that is congressional intent. There has to be some clue that Congress intended for the ARP to serve as the remedy for the violations of Mr. Butler's rights in order for its existence to foreclose the availability of a Bivens remedy at all. And no such clue exists here. The last quick alternative remedy point I'd like to make is that the district court and the government rely on injunctive relief as an alternative remedy, but injunctive relief was not available to Mr. Butler here either. As the record indicates on page 42, Mr. Butler did request injunctive relief after about 8 months in the shoe. However, by the time the magistrate judge issued the first R&R in 2017, Mr. Butler had been transferred from Oakdale, rendering, as the magistrate judge noted, rendering his claim for injunctive relief moot. To conclude, overall, as Judge Graves noted in his dissent in the Cantu versus Moody case, extending Bivens is a disfavored judicial remedy, but it still is a judicial remedy in certain circumstances, and we believe that those circumstances are present here. Therefore, we respectfully ask that the district court be reversed. Thank you.
Thank you, Mr. Rios. Mr. Quast?
May it please the court. Paul Quast from the United States Department of Justice. I represent the 11 Bureau of Prisons, correctional, investigative, and unit management staff defendants here. The district court correctly declined to create a Bivens cause of action in the First Amendment retaliation claim in the prison housing context. The Supreme Court has never recognized a Bivens remedy in any First Amendment context, and every court of appeals to address the issue of whether or not to create a remedy in the prison for a retaliation claim in the prison context, every court of appeals has declined to do so. Now, plaintiff seeks to dispute this overwhelming weight of precedent and authority, essentially by asking this court to ignore Bivens jurisprudence in the modern era, both this circuit's jurisprudence and Supreme Court's jurisprudence. So, for example, as recently as last year, this circuit has rejected an argument like plaintiff is now making that the PLRA was in fact a ratification of Bivens claims in the prison context writ large, and not in fact a sign that Congress did not want more Bivens claims. In the United States versus Canada case, this circuit said it is inconsistent with the Supreme Court's later opinions to the effect that legislative inaction is not inadvertent when Congress repeatedly enacts legislation to reform an administrative process, but at no point chose to extend the kind of remedies sought. Congress has never created the remedy that plaintiff seeks here. Congress, in fact, has acted repeatedly to give deference to the executive branch in housing inmates, in deciding how inmates should seek out their claims, and what to do if those administrative processes aren't available. Which brings me to plaintiff's alternative process points. Plaintiff's counsel states that injunctive relief wasn't available here and that the administrative process couldn't have been an alternative remedy for him because he was not successful in those processes and because he was being retaliated against for engaging in those processes. I mean, the simple fact of the matter is plaintiff repeatedly throughout the record says that he did engage in those processes. He raised the exact retaliation claims that he now brings that he now is seeking to bring through a Bivens lawsuit. And merely the fact that he was unsuccessful does not mean that the process was not available to him. Moreover, it's not even about whether a process is available or will be successful for a given plaintiff in a given case. As the Supreme Court said in the Malesko decision, so long as the plaintiff had an avenue for some redress, an avenue. The bedrock principles of separation of powers foreclose judicial imposition of a new substantive liability. Contrary to plaintiff's arguments about the administrative remedy process, administrative processes have been acknowledged by this circuit, other circuits, the Ninth Circuit in Vega, this circuit.
What about the argument, though, that that's what caused them to come after him? His complaints is what caused the retaliation. So and not only are they not helpful, they're harmful.
Yes, Your Honor. Congress anticipated this very issue in the designing the ARP and in making a bypass mechanism. So where a plaintiff like here is saying that the process wasn't available to him, Congress thought through that and said, okay, where it's not available to an individual plaintiff, then they can go immediately to district court and seek injunctive relief. Congress set up, I mean, you could really view it as one process here. The first step is to proceed informal remedy, official remedy, appeal within the process. If that whole part of the process isn't available to him, then he can immediately seek relief in federal court. Here, plaintiff sought relief in the wrong federal court, which is why the court said, below here, said they didn't have jurisdiction to release him from the SHU in California. But that doesn't mean that a process wasn't available to him. And indeed, Ziegler v. Abbasi, the Supreme Court said that injunctive relief can be a faster and more direct route to relief, thus obviating the need for the court to stick its neck out and create a Bivens cause of action. Like you said, Judge Haynes, making the law, not just enforcing laws that Congress had created. Indeed, it would be going beyond what Congress anticipated in the PLRA in setting up that two-stage process. And even before, it's not just the PLRA, of course. Other congressional action exists here, such as CRIPA before then, which was modified by the PLRA, the First Step Act recently, dealing with prison housing, stripping the courts of authority to review certain prison housing decisions, and generally the decades of legislation before then, giving the Attorney General, Bureau of Prisons, the discretion to house inmates where they see fit. And that makes sense. It made sense for Congress to leave that to the executive branch to house prisoners where they see fit, because as the courts have recognized, the Supreme Court's recognized in Turner v. Safley, in the Overton decision, prison management, prison decisions should be left to the experts, which are prison officials. Now, that's just a general. You're saying
whether it's executive or legislative, it sure ain't judicial branch.
That's absolutely correct. And in terms of the separation of powers, which the legislative action implicate here, it is both that Congress said executive branch, design this process, and we'll have that process be the initial stage for seeking relief for any conditions within a federal prison. But also there's less of a need for, on the other hand, there's less of a need for courts to act as well. So it's really both and here, because plaintiff had these alternative remedies, both through the administrative remedy process, injunctive relief, and the other remedies mentioned in our briefing. Plaintiff also discusses qualified immunity as essentially giving license to this court to expand Bivens. The Supreme Court has always separated out the qualified immunity and creation of a cause of action remedies being merits versus whether a cause of action exists.
They remanded to us on that in Hernandez, right?
Right, exactly, which is why it's appropriate for the court to address this antecedent question of whether or not to create a cause of action here. And what courts have found that even in light of the qualified immunity defense that federal employees have, these types of retaliation claims, like I said, even with qualified immunity, are not amenable to early decision. I think the Supreme Court in Crawford L and the Third Circuit in Mack said that these claims are easy to plead and difficult to disprove. So even with that robust defense of qualified immunity, you're still going to have potentially all of these retaliation cases that can be easily pled and won't be resolved until trial, burdening the judiciary, who both has to screen these claims and handle them later on, but also the government, who defends the majority of these claims, and the individual defendants themselves, of course, who are subject to potentially personal liability in these cases. So those, I don't think qualified immunity cuts in favor of the plaintiff here, or can be seen as giving license to create a Bivens cause of action. Now, plaintiff says that the increased costs could be a reason to decline to create a Bivens cause of action in any case, and essentially that would they claim that this would be a justification for always declining to expand Bivens. Bivens is a disfavored remedy, and there are many justifications for why it would not be expanded. But more fundamentally, these types of retaliation claims are not just any case. Unlike the cases Carlson, Davis, Bivens, where the Supreme Court has affirmatively recognized a Bivens claim in the past, retaliation claims, as I mentioned earlier, have been recognized as the court as causing uniquely higher costs. They involve more difficult issues of causation, which is exactly the kind of concern the court had in Bush v. Lucas and said could be a cause to hesitate before expanding a Bivens remedy. They isolated particularly tricky issues of causation. Also, unlike in Carlson, where deliberate indifference would have needed to be pled in order to raise an Eighth Amendment claim, any more than de minimis adverse action could form the basis for a retaliation claim. So this could be anything from shoe placement for retaliation, loss of a commissary job, loss of good time point. There are just innumerable actions that the Bureau of Prisons could take that if the prisoner had previously filed the grievance, would now be constitutionalized potentially as a potential retaliation claims. So that not only makes these easier to plead, but also just opens up the universe of when these cases could be pled. As we noted in our brief, there are many prisons, many federal prisoners in the United States. It's just a wide universe of potential cases. Opening the floodgates is absolutely a concern here.
What about the Eighth Amendment argument that we should remand and let him plead more fulsomely the cold shower and the deliberate indifference to medical and so on?
As to the plaintiff's Eighth Amendment claims, there were no Eighth Amendment claims in the original complaint. I believe the court mentioned that he stated the facts, but he didn't say Eighth Amendment. We would disagree with that characterization. Not even the facts were there in the original complaint. For example, on record of appeal 38, he said, there are other negative shoe conditions that, although typical of all prisoners' shoes, are notable, including that the showers often run cold. This doesn't speak to the kind of individualized misconduct that would raise or even speak to an Eighth Amendment harm that the court has said is a necessary predicate for a Bivens action. This doesn't speak to wanton infliction of harm. This certainly doesn't speak to deliberate indifference or any sort of intentionality like that, linked with the fact that no individual is named as being responsible. In fact, later on in the case, plaintiff points out that the cold showers were due to a mechanical failure. Now, for that cold shower point in particular, plaintiff points to record of appeal 107, 156. These are the same document that was filed twice. So there's really only one document. This was not a supplement to the complaint, as plaintiff characterizes it. This was a letter to the court asking for injunctive relief to end retaliation. This is the other big problem with now what plaintiff is trying to transform their Fifth and First Amendment claims into Eighth Amendment claims, essentially excise out from those discussions of here's how my due process was being violated, here's how I was being retaliated against, and take little snippets out of that and say that forms an Eighth Amendment claim. I think that would be an impossible standard for district courts to follow. The magistrate judge did a thorough decision here, analyzing all of these facts that plaintiff raised in the light of just how plaintiff alleged them, which was as negative consequences of being housed in the special housing unit.
So, given though that when you have a pro se litigant, you're supposed to liberally construe and all of that, how do you explain the lack of liberally construing these facts as the Eighth Amendment claim, or where is that line that's drawn between becoming the lawyer as the magistrate judge, becoming the lawyer for the pro se litigant, which you shouldn't be, and liberally construing, which you should?
So if the court were to be viewed, if the district court had said there are Eighth Amendment claims here, that wouldn't have been liberally construing plaintiff's complaint. That would have been manufacturing claims for plaintiff. I think the question
that's crossing that line from liberal construction to becoming the lawyer for.
Right, exactly. So for example, plaintiff says again for his eyeglasses claim that he was never provided eye care when he was in the special housing unit, and this act exacerbated the harm of him being held in there. He doesn't say that some individual person violated his rights by declining to do that. Now, this probably doesn't even rise to the level of a serious medical harm, but even if it did, he doesn't allege the kind of intentionality. So none of the kinds of elements are there that would even speak to an Eighth Amendment claim. And to be perfectly clear on this, I'm not just saying that he failed to state an Eighth Amendment claim or that the law wasn't clearly established that these were Eighth Amendment violations. I'm saying there were no Eighth Amendment claims in the complaint whatsoever, whether for cold showers or for being deliberately indifferent to his medical harm. So for example, plaintiff tries to rely on documents like ROA 409 or other later filed documents. These are all documents outside of the complaint. As the court recognized, the district court cut him a lot of leniency. The district court acknowledged six supplemental documents after his initial complaint, I believe, all as part of his complaint in a very generous reading of the federal.
What about the argument that allowing the supplemental does not sort of give the magistrate judge credit for having allowed amended?
Right. So the district court or the magistrate judge did allow him to amend it just as to the First Amendment retaliation claim, but there would have been no need to allow him to amend to replead or fix Eighth Amendment claims because they were simply not there. And this magistrate judge at that time had been on the bench for nearly a decade. She sits in a district where there's a federal prison, I believe a federal immigration facility as well. She's well versed with these. There would have been no reason to ignore an Eighth Amendment claim if they were there, but plaintiff simply pleaded retaliation claims. At some
point, he did use the phrase Eighth Amendment, correct?
Correct, yes. In briefs, never in a...
Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States in this honorable court.
That he wanted to amend.
Thank you and welcome everybody. We are glad to have you today. Just a few reminders. You are not to photograph or videotape or audio tape this proceeding.
Off the top of my head, Your Honor, I do not.
Please recall that you should mute yourself when you are not talking, but unmute yourself when you are talking.
You cannot amend a complaint
and please, when you reference facts in the case, we would appreciate record sites.
And it was after.
And please recall that rebuttal is for rebuttal only. And with that, we will begin case number 20-30240, Miller versus Reliance Standard Life Insurance Company, and we'll begin with Mr. Toledano for Michael Miller.
You will note that I do not represent any prison medical staff here. These defendants are not even alleged to have done anything in those claims. Would have really been a stretch of joinder issues, in addition to being too late, and may have had even other problems if he had attempted to add new claims.
The most important reason is this policy had a transfer of insurance coverage provision, whereby Mr. Miller was to receive credit for the previous time he's been insured under the plan.
Turning back briefly to the First Amendment claim, Your Honor, which as plaintiffs acknowledge in their oral argument form is the core issue in this.
He was the president for many years. He's always been insured.
When the PLRA was passed,
in 2015, he had to take disability leave.
So
and during that leave of absence,
Congress had not ratified First Amendment retaliation claims to that
Lake
extent.
Charles pilots decided to switch.
But it's not just PLRA that we're asking the court to take notice of here when we're asking the court to say that congressional action counsel's hesitation. It's all of the other activity that Congress had taken in terms of stripping
eventually
courts
returned to work
of the ability to
and,
review housing decisions
he
and give
became
plaintiffs,
disabled
prisoner
again,
plaintiffs, the
and
opportunity
the issue
to
became whether
challenge their
the pre-existing condition
prison
clause
housing
applies.
conditions.
The policy has a transfer of insurance coverage provision that's set, and there's several requirements of that. But one of the requirements, and the one that's at issue today, is
If your
whether he
honors
was
have
an active
no other
full-time
questions,
employee on the day
I would ask that the Court of Appeals
Reliance
affirm
began
the
insuring
district
the
court's
plan.
decision.
Mr. Toledano,
and decline
I
to
was not
create
an
a
insurance
novel
attorney,
business
so I
cause of
need to
action
be
in the
spoon-fed
First Amendment
this.
retaliation claim.
Uh,
Thank you.
You know, I need you to hold my hand and
Thank you,
walk me
Counsel. Mr.
carefully
Bakke,
through
you
this
have a
because I
vote.
get lost. As I understand, you're saying whether he was active is the key part, because if he's not active, then he's not an eligible person with respect to the transfer provision. Am I following?
That's correct. The requirement is that he needs to be an active full-time employee on the date of the transfer.
Okay.
That's right.
And just one other question,
A
just
few points on rebuttal,
sort
Your
of
Honor. So
preliminary
first, I
question.
wanted to get back to Judge
We're not
Haynes'
talking about
question
whether
about
he was actively
whether
at
Mr. Butler
work,
had objected to
which is a defined
the
term.
denial of his motion
Right.
to appoint
Because
counsel.
as I understand it, correct me if
He
I'm wrong, the
did.
parties agreed
That
that he
motion
wasn't,
was
quote,
denied
actively
at
at
ECF
work,
14.
such
Mr.
that
Butler
the first
objected
paragraph
at
of the
ECF
transfer provision
18,
would sort of
ROA
take care of
104.
this. Is that right?
And that objection was
That's
directed
right.
to the
That's
clerk of
undisputed.
court
He was
Okay.
rather than to the district judge.
Yeah, he was not
And if there's
actively
any
at
more
work,
questions
and
on this
but
point,
he
Your
was
Honor,
an
I'd be
active
happy
full-time
to
employee.
file a
As
28J
and the
letter
Sixth Circuit in
to
Wallace
brief that
decided
issue.
literally this exact
Turning to
this
the
exact
back
same
to the Eighth
policy
Amendment
language,
claims,
this exact same factual circumstances.
Opposing counsel
claimant
suggests
there
that
was
there
out of work
simply
on
were
disability leave,
no
just
Eighth
like Michael
Amendment
Miller,
claims in Mr. Butler's
and
complaint.
Reliance denied the claim,
We
and
think
they
that
said
is
that she
obviously
was
not
not an active
true. He's
full-time
alleged
employee
the cold
because she was
showers
not
claim. He's
actively at work.
alleged the deliberate
Actively
indifference
at work,
claims.
as noted by the
Opposing
Sixth
counsel
Circuit, is
also
a term of art
speculates
defined in
that
the plan and has certain meaning.
certain conditions weren't
But
serious enough
the
to make
eligible
out a
employee
deliberate
section of the
indifference
policy
claim.
does
For
not,
example, on the eye care,
require
yet in our
active-
briefs, we cite a
being
number of
actively at work. It
cases
just
where
requires that the person being active.
other courts have
full-time
recognized that
employee.
similar conditions
And
have
the Sixth Circuit concluded
give rise to a
that
cognizable
could
Eighth
include
Amendment
someone
claim.
who's not retired, someone who's still an employee.
In
of
any
the
event,
plan,
I
but
would
just
like to
happens
reiterate
not be
that
at
to
work
the
that
extent
day
that
when
no
the
one
insurance took effect.
reviewing
Well, I
these
assume
claims
from
could
that
have understood
definition
Mr.
that
Butler to be
active has to
bringing
have a
Eighth
meaning
Amendment
independent
claims.
of full-time.
One thing was unmistakably clear, and that's
You have to
that
be both
Mr.
an
Butler
active
was
employee
ready
and
to
a
file an
full-time
amended
employee?
complaint. He
That's
thought
right.
he had stated these
Okay,
claims.
so help me
yet
with,
the
I get
district
that
court
active is
improperly,
different from the defined term
denied
active
that
at work.
motion.
I get that. Help me with how should I think about active?
The First Amendment Bivens issue,
in that,
a few points
because
here.
it's not defined in the
The
policy.
court
So
has
what
some
does it mean
concern about
to be an active
requiring
full-time?
an inquiry
Well,
of subjective
one example that comes to
intent
mind is think about
into the
someone
federal
who's in the
defendants. But
They're
that's not a concern
actively serving
in
the military,
Bivens
but they might
actions,
not
as
be at work
evidenced
on
by the
certain day
fact
because
that
they're
the Supreme Court in
weekend or
Davis
they're on
versus
sick leave.
Passman recognized a
but they're
Bivens
still
remedy
active
for a
employees.
sex
As long as they're
discrimination
not
claim,
terminated employees,
which
or they haven't
ostensibly also
retired,
requires
they are active.
subjective intent.
And that is what the Sixth Circuit found. And the Sixth Circuit said, at the very least, it's
If
ambiguous.
the court has no further questions,
Because, if
we
they
would
really
like to
wanted
thank the court
there
for
to
the
be an
opportunity
actively at
to
work
present Mr.
requirement,
Butler's
they should have said
argument,
so
and for
clearly
the
in
rest
policy.
of our
And
arguments,
they
we
did.
rely on our briefs.
They just say active full-time employee, and
Well, they kind of actually said the opposite. I mean, that second
muted.
paragraph is expressly for somebody who wasn't actively at work.
Mr. Bakke,
Due
and
to
Mr.
injury or
Rios,
sickness.
we thank you very much for representing
Right.
Mr. Butler.
that's right.
Pro se, and for
Okay,
the
so
excellent job you've done. In
It
this
seems
court.
like you have the actively at
Assisting
work,
with us
paragraph
and,
1, and paragraph 2
analyzing
is
this.
somebody
Thank you very
else.
much.
Because if you're actively at work in paragraph 1, you
Thank
would
you,
need
Chief Judge
paragraph
Owen.
2. Paragraph 2
That will
says
conclude the argument this afternoon.
that
This
blah,
case
blah,
is
blah,
under
but
submission.
not actively
Thank
at work due to injury or sickness and would otherwise qualify as an eligible person. So to me, it seems like active has to mean something other than me sitting in this chair right now where I'm actively at work.
Yeah, it means, I believe what it means is what the Sixth Circuit found it to mean, and what also this court decided it meant in the Jackson case, which was an unpublished decision, but it was very similar to the reasoning that the Sixth Circuit employed. But I believe it meant that you're still an employee, you're just out at the time, and you can be, as long as you're not retired or you haven't been laid off, you are still an active employee. You're just not there at that moment because you're out on sick leave or you're for some other reason. Maybe it's the weekend, maybe it's a holiday, the day that the insurance took effect. But I think at best it's ambiguous. And under an ambiguity, under the Fifth Circuit jurisprudence, he should win. And he shouldn't have to face a pre-existing condition exclusion whatsoever.
Well, no, you please go ahead if you want to say more about active.
I don't know what else to add to that other than it doesn't mean actively at work.
Remind me, did the district court really address this idea of active and eligible person in the transfer? Or did the district court focus more on the payment of premiums?
The district court did. I believe that the district court did find that that he was not actively at work. So the court read into a requirement that he had to be actively at work. The court essentially bought Reliance's argument at the district court level, which was contrary to the Sixth Circuit's decision.
Okay, so there's that issue, and then the district court did find that premiums had not been paid. I'm probably getting the language wrong.
That's correct. The district court made a ruling that the premiums were not paid, which to this day I don't understand why. First of all, that issue should not have been taken up by the court at all because Reliance failed to assert it during the administrative process. And the essence of an ERISA case is a review of an administrative record where Reliance explains all of its arguments, we get to rebut them, and then we're sitting at the district court level almost in an appellate capacity. And here we never got that because Reliance, for the very first time, alleged that the premiums weren't paid while we were briefing the motions for summary judgment. And it simply was untrue. The reason why they never argued this at the district court level is because it was untrue. Reliance knew all along that the premiums were paid. They had the information showing that the premiums were paid. So as soon as they made that argument, which I don't believe the court should have allowed them to make it after the fact, but assuming that the court allowed it, we moved to supplement the administrative record with a declaration from the insurance agent showing that the premiums were in fact paid. And we also provided a detailed invoice a paid invoice that demonstrates that Michael Miller's specific premium amount was included in that amount, and they received the full amount of that payment. I don't know what else we could have possibly, we could all have submitted more, but that was the best evidence we could show that the premiums were paid. And somehow the court said they weren't. The only thing I can think of is the court got a little bit mixed up because Reliance had stated in its brief that the premiums were not paid. And maybe the court took them at their word on that.
Hey, what's weird to me about that is that's something that is clearly within Reliance's knowledge to ascertain. It's not something they can only get from you, like what is your social security number or something like that. They know they were paid the premium. So I'm just confused a little bit by the whole. I guess they're just arguing you had a burden of proof at the administrative proceeding and you didn't meet it, but they didn't say that. So I don't know. I find it a confusing argument by Reliance.
You and me both, absolutely. And the Sixth Circuit was a little bit perplexed by it as well, and they noted in their opinion that Reliance is the one that knows whether the premiums were paid. And they approved 2 different short-term disability claims for Mr. Miller. And had he not paid his premiums, that would have been the first thing they would have said. They would have said you had no coverage here, and we wouldn't even been arguing about anything about the pre-existing condition because he either would have had coverage or not. And in our appeal, we argued that the premiums were not paid, and there was just no reason to provide any other information because Reliance had all the information. The information ultimately that we gave to the court that showed that the premiums were paid were on Reliance's letterhead. It was basically the paid invoice that Reliance had in its own possession. And Reliance could have simply, asked Reliance's attorney could have simply asked its client, were the premiums paid while we were litigating this issue? But it was just, I don't know, but.
Well, I guess we'll see if Reliance is going to continue to press that argument when they argue. Can I ask you sort of about an order of decisions? Let's assume the panel agrees with you that the transfer provision applies. Do we need to reach the other issues in the case? And I'm thinking specifically about whether the right knee disability is an excluded pre-existing condition, and then about whether the neck and back disabilities are substantiated by the record.
No. Basically, if the transfer of insurance coverage provision applies, then there's no need to get into whether the back or the knee were pre-existing conditions because the pre-existing condition clause does not apply whatsoever. is not an issue. And these policies are designed this way. They're designed to credit periods that claimants have been insured under the plan before they become insured. And that's exactly what this policy did. And it just so happened that Mr. Miller was out on disability leave on the day that Reliance began insuring the plan, but we believe he still has coverage. His coverage should transfer. It's just, and here's a guy that paid these premiums for years and years and years. He was the guy that started the group disability plan. I mean, this was
the Sixth Circuit. I believe it remanded for further proceedings, maybe for some fact finding. If we agreed with you, do we need to remand?
I don't believe so, because the reason why the Sixth Circuit remanded was because the district court never looked into whether he was a full-time employee. So that was an issue in that case. In our case, in the Miller case, there's no issue of whether he was full-time or not. When he was working full-time. There's no part-time employment for a bar pilot. And there was evidence in the record, which we cited into our brief, that showed that his schedule was basically, I think it was 2 weeks on, 2 weeks off, or some sort of schedule like that. But it was full-time employment. He was working a minimum of 30 hours a week when he was working. That's demonstrated in the pay stubs that are provided. We cited it into our brief. So there's no reason to remand at this point. He was an active full-time employee at the date that Reliance began insuring the plan. He's entitled to his credit for his time towards the pre-existing condition limitation that he had already developed.
Let me ask you this on the premium issue. Is the fact that they did pay the short-term disability some evidence that the premiums had been paid? Your point earlier that insurance companies, I have a lot of experience with insurance companies, and it appears to me that typically they don't offer coverage when you haven't paid your premiums. So would that be some evidence of that, the fact that they had paid those short-term disability, would that be some evidence that they did in fact get paid a premium?
Yes, it would, because that would have been the first thing they would have checked is whether the premiums were paid. And if that weren't the case, they would have denied the claim. It simply was never an issue until Reliance's attorney brought it up in the litigation, and Reliance would have never brought this up because they knew the premiums were paid. And there was the record actually showed that the premiums were paid. There were some claims.
Again, it's a little bit of a technical argument, I think, that they're now claiming, which is that you didn't prove it in the administrative proceeding. So maybe it was paid, but you didn't prove it. And that's why I was asking whether the payment by the insurance company of the short-term disability was circumstantial evidence of the premium payment.
Yes, that's their argument, but it's also, I don't think, a fair argument. He also didn't provide his birth certificate to prove that his name was Michael Miller. There was no reason to prove something that Reliance knows all along. And Reliance never denied the appeal. They never made a decision on the appeal. They just simply ignored it. And that's another factor here. Had he not paid his premiums, it would have been something, first of all, they wouldn't have approved two separate short-term disability plans. There wouldn't have been claims notes saying that the premiums were paid. But they also would, when they got the appeal, they would have denied the appeal saying the premiums weren't paid. And then we could have done something about it. We could have said, okay, well, here's some evidence showing that the premiums were paid that you have in your possession, but we'll give it to you again. But it's simply it was just never an issue. And that's one of the reasons why in an ERISA case, they're not supposed to be allowed to make arguments that weren't made during the administrative process. Because we could have demonstrated this during the administrative process. We wouldn't have had to have moved to supplement the record while we were doing the cross motions for summary judgment at that point. But
okay, I'm going to give you 1 extra minute and your opponent 1 extra minute if you want to cover the knee, neck, back.
Sure. If the pre-existing condition clause does apply, we believe that he's still entitled to benefits under the policy because he did not receive treatment for his right knee or for his back and neck pain during the look-back period. And if you go through the medical records, which we tried to summarize in the briefs and at the district court level, you'll see that he didn't have treatment for those conditions. Now, Reliance argues that there was one medical record, I think from a physical therapist, that said that he was rehabbing the knees at one point at time. It was actually not from the physical therapist. It was from the doctor he was seeing for his wrist pain. And he noted in that record that he was rehabbing his knees. And Reliance is saying that equated to treatment for that condition or consultation for that treatment, which would trigger the look-back clause. But we believe it did not, and because he wasn't even treating with that doctor, and he wasn't rehabbing his knees. He was rehabbing his left knee at the time, but not his right knee. So we believe his right knee is disabling, independent of his other conditions, and we also believe his back and his neck pain. He's got significant stenosis in his spine.
Your time is up. You've reserved some time for rebuttal, and we'll now hear from opposing counsel.
May it please the court. Good afternoon, Your Honors. Joshua Backrack, represent Reliance Standard Life. I think it's important to look at the, because your Honors have asked the questions about the coverage language in the policy, the active language. And I think it's important, under ERISA, you have to read language together. And this policy says you have to be an active full-time employee. And full-time is defined as working for your employer for a minimum of 30 hours per week during your regular work week. And counsel didn't address that language, during your regular work week.
Well, so I agree. What was Mr. Miller's regular work week? Was it 30 hours?
Mr. Miller had no regular work week on or about September 1, 2015, because he was already disabled.
But when he was at work, what was his regular work week?
Well, that, I don't know that has been established, because counsel hasn't established that. There's some evidence he worked 2 weeks, then he'd be off 2 weeks. I don't know that, so at what point is it that he did that regularly? Because that's the language, regular work week. So we know in July, as of July 1, 2015, he stops working, and he doesn't work again until 1 year later. So we have a whole year where there is no work at all, 0 hours for that entire span. So to say that he had a regular work week years ago, that doesn't qualify, because the policy looks to, at the time of the transfer of coverage on September 1, 2015, did he regularly work a minimum of 30 hours a week? And the answer to that is no. I don't understand
why you have this second paragraph that says explicitly, but was not actively at work due to injury or sickness on the effective date of this policy and would otherwise qualify. I mean, why are we going to have that if we're requiring that his regular work week be going on right then?
I'll explain it, Your Honor. And it's important, I'm going to put in the context of comments that counsel made. So counsel said that this transfer of insurance coverage protects somebody if they are, quote, not working that day, end quote. And later he said that somebody may be off during a weekend or on a holiday, and this protects their coverage. And that is the purpose, because if a person is missing a day or two at the time of there's a transfer from one carrier to another, this protects them. So if it happens to be during a holiday and they're not working that day, they're going to be insured by Reliance. If they're out sick due to a cold or a flu, they're going to be insured by Reliance.
Okay, but what about if they had COVID and they were in the hospital for 3 months? Would that count?
If their hospitalization began 3 months earlier, and I don't think you have to say COVID, it could be anything. If their regular work week as of September 1, and you look, again, regular. So what does that mean? That means on a regular basis, on a consistent basis. That's what the dictionary, we provided the dictionary definitions of what regular means in our briefs. So on a regular basis, as of September 1, he had to regularly work 30 hours a week, and he didn't.
Yeah, but let's say on July 1, he got COVID and ended up in the hospital, and September 1, he's still there. But prior to that, he had worked 30 years, 60 hours a week. Let's just give that hypo. Why would he not be covered? Why would this not apply?
Because he's not regularly working as of September 1. I believe it's unreasonable to say that in the context of the words active, what active means, and regularly working, which is a definition of full-time, that a person who has not worked in approximately 3 months, and when you look in the aggregate, has not worked in a complete year, they are not regularly working the required number of hours.
But we don't look at the aggregate. We're looking at the effective date. And I guess
Correct.
I don't really understand the purpose of this second paragraph if it's not going to apply to someone who's been, I don't know, I don't remember, he said something like 20, 30 years at this company. He's been there a long, long time, working regularly. Then he gets sick and he's gone for a while. At that point, 3 months or 2 months, I get. Well, was it November? I mean, so was it September or October? Remind me. Okay, yeah, July to, okay, 2 months. So 2 months he had been gone. Where is it in this policy that it differentiates between a week in the hospital for COVID, 2 weeks, a month, 2 months? Where does it differentiate that? Because we have all kinds of people that are in the hospital for several months and then wonderfully they get out and they're back in the world. Some of them pass away, sadly, but that's a real event right now. So why, I mean, how are we supposed to differentiate? Is it the 1 week COVID person, the 2 week, a month, 2 months?
Your Honor, I think you have to look at the language in the policy. The language in the policy is active, which means we cite to a 10th Circuit decision. It means actually working, performing your duties. But then you have to read in conjunction with the definition of full-time, regularly doing that. So you must be regularly working at the transfer date. And this person was not, if he's not working if he's not working in 2 months. And I know Your Honor keeps mentioning COVID. It's regardless of maybe that is an issue today in other cases, but that's not the issue here. And I think that just in some ways prejudices the issues in this case, because the transfer of insurance.
If we have to construe the policy, I mean, whatever we issue in this opinion is going to affect future opinions. And so if we were to rule that you could only be off for a weekend or only sick for 1 day, a flu for 1 day is good enough, but a COVID for a week is not, that is going to affect people. I'm not saying, I mean, we have to follow the law whether it hurts or helps people. That's not my point. But my point is it does matter what our construction is. And so I'm just trying to understand your argument, because this notion that you have to be regularly at work is to me inconsistent with the second paragraph that understands you might be injured or sick.
I don't believe it is inconsistent. What they're trying to do is to say if you are injured or sick for a day, for a few days, you're not going to lose your coverage. But Your Honor,
how many days? If you're writing our opinion, so you're writing the opinion, how many days do we put down?
I would look at the dictionary definition of regular, which is in my briefs, which is regular means on a consistent basis, on a scheduled basis. And when you look at that, this person was not scheduled or consistently working on September 1, 2015 with any regularity because he hadn't worked in 2 months. I don't think, and it's hard to put some temporal meaning except for regular, the definition of regular, which means consistent. And on a consistent basis, as of September 1, he was not regularly working 30 hours a week because he had not done so since June 26th, I believe, the last day that he regularly worked. I don't think a person would say that, I'm regularly working. And by the way, that's a word in the policy. It says full-time means working for your employer for a minimum of 30 hours per week during your regular work week. Not that you have worked in the past for 30 hours a week. And counsel mentioned the Jackson case, which is an unpublished decision. In that case, it involved very different language. That case had language that defined it as working as required by the employer. This policy doesn't.
I have two questions since you're talking about the case law.
Yes,
well, my first question is not related to the case law. What about are you still pursuing the premium issue that we discussed with your opponent, number one? And secondly, with regard to the case law, how do you distinguish Wallace? Would you please take us through that?
Certainly, Your Honor. So as far as the premium issue goes, counsel is saying we waived the issue because we didn't address it. But again, it's his burden. And that was the point I was making. He said in his letter that I paid premiums, but he provided no proof. That's like saying I'm disabled, but you don't give a doctor's note. Judge Haynes, you said, but you should have the information. We don't, because this is group coverage. So the employer submits the premium on behalf of everybody, and that goes to a premium billing unit. And the claims department would have that information. They wouldn't. They would know if premiums were paid by the group, but unless somebody affirmatively states that premiums were paid by this individual, they would not necessarily have that.
Why would you recognize a short-term disability if you hadn't paid premiums?
It was a mistake, frankly.
Twice?
No, because the second claim, so there are two claims, October 23, 2015, and then the one from August of 2016. So let's look at the 2015 claim first. Short-term disability was paid. That was a mistake. The long-term disability was denied on that one for the very reason that there was no coverage. Reliance realized at the time that it shouldn't have approved the short-term disability because he was not covered as of September 1, the transfer date.
The mistake that it has to do with premiums, though, right?
What does it have to do with premiums? Well,
Yeah.
Counsel argued they paid the short-term, therefore they acknowledged there's coverage. That's not true because they denied the 2015 long-term disability claim. There's no waiver here. But what it has to do with premiums is what they look to is have premiums been paid by the employer? And then the employer is the one who says, yes, this person paid premiums or was paying premiums. So we have to rely on what the employer says.
Before you pay any benefits under the insurance, before your client pays any benefits under the insurance, they are going to check that this person is one of the insured people, at least as far as premiums being paid. If they're not going to check it, then why should we, years later enforce something you're not even enforcing?
Your Honor, they're not checking it, except they are checking it to see has the group paid the premiums. And then if they learn later on, it's an issue. And this is the point I was getting for Judge Engelhardt. It's not an issue. The premium issue part here, apparently there has been information submitted that he did pay it. That hasn't been our defense. In our briefs and counsel saying I've misrepresented to the courts, I have not, and I'm offended by that. But the fact is, we stated from the start that the information that should have been provided wasn't, but that we've never contested it in subsequent briefs.
So just so I understand, is it an issue that this panel needs to decide? In other words, is that a reason why the transfer provision does not apply?
No, Your Honor, you don't need to address it because
what?
He has to prove before. You can't just say premiums were paid, therefore transfer of insurance coverage.
Yeah, I get that.
The first thing you have to show is he's eligible. He's an eligible class.
But right. But so let's say hypothetically we say he's eligible. Is the non-payment of premiums then something we have to decide?
No.
Why not?
No, Your Honor. Because based on information that I will add was improperly obtained by counsel. Counsel contacted my client directly during the litigation, which I have a lot of problems with that conduct, but that information shows that premiums were accepted by Reliance from his client.
Okay, so, look, I mean, I don't want to get into, all I'm asking about, I'm not asking about litigation conduct. I'm asking about, for purposes of this appeal, do you concede that premiums paid is not a reason for saying that the transfer provision does not apply?
Yes, Your Honor. Okay. I agree. And we've said that. I believe I said it in the response.
You need to address the Wallace question.
Yeah, can we get to Wallace?
Yeah.
Yes. So that's a good point. So in the Wallace case, what the Sixth Circuit said in that case was that there were no findings by the district court on whether the employer had established regular full-time whether there were regular full-time hours for this person. And since there was no fact finding on the issue of regular full-time, that issue was remanded back from the appellate court. But in this case, and one of, I apologize, I don't recall who, one of your honors had asked whether there was a decision on that issue in this case. And there were specific fact findings, and we cite to them towards the end of our brief. But there were specific fact findings by the district court in this case on why he wasn't, in fact, an eligible person, part of that being that he was not an active full-time employee regularly working 30 hours a week. And the court mentioned the fact that he had not worked since late June of 2015. The court mentioned the fact that he was out of work due to the disability and did not work again for quite a period of time.
Okay, let me ask you this, though. Why would the language then be, okay, was not actively at work due to injury or sickness on the effective date and would otherwise qualify? So if he was not sick or injured, he would otherwise qualify. If he was not sitting in the hospital, if he was not sitting at home injured, he would otherwise qualify. Why doesn't that take us back to the moment before the injury or sickness?
Your Honor, that goes back to the point, and maybe I'm not saying it as well as I can, and I hope I do better now. So if he was injured or sick the day before, August 31st of 2015, if he is sick on that date or it's a holiday, and so on the next day, the coverage comes into effect and he's not at work that day, he's not going to lose coverage. But it was never intended to have somebody who hasn't worked in 2 months. So what happens if he's still paying premiums, Your Honor, and he hasn't worked in 2 years? Is he still regularly working?
I mean, y'all write the policy. You can certainly say otherwise qualify for this many months, this many days, whatever. But to me, otherwise qualify means if he weren't injured or sick, he would have been an eligible person, yada, yada, yada. And so that seems to me that you don't count the time he's injured or sick, and you look before that. And before that, he started in 1989 and has been working there for 26 years or something like that. I'm not very good at math, but something like 26 years. So that would seem like he otherwise would qualify had he not been injured or sick. Otherwise qualify, yeah. So that strikes me as, if you all wanted to be specific that the injury or sickness had to be only a week or something like that, you absolutely could put that in there. And I respect that. I very much respect the right of insurance companies, within the law, obviously, to write policies how they want to. But that otherwise qualified, to me, makes no sense if we're going to say the day he was injured or sick, he still has to be working full time and regularly and all that, but we won't count that one day, we only count the day before, whatever, because I just don't see that in here.
Well, Your Honor, you're saying you have to look at before. And before, for 2 months, he hadn't worked at all. So he was not regularly working a minimum of 30 hours a week. But I think you also have to look in the context, and I'm trying to find the exact language in the policy on where the otherwise comes. And you have to, it says that a person they still have to be in an eligible class.
Okay, where's the word still?
No, I'm adding the word still,
Okay.
but the language is
reading
there
it.
that they have to be in an eligible class.
Okay, I get that, but what I'm trying to understand is, but was not actively at work due to injury or sickness on the effective date and would otherwise qualify. What does the word otherwise refer to here?
Let me just look at it briefly, Your Honor, so I can answer that. So I believe this goes back to what I was saying. So if they are out due to injury or sickness on the day this policy is to go into effect, and that's what it's talking about, on the day prior to this policy's effective date, right? If they're not there, their coverage under some interpretations might have ended. They may not have transferred here. But what this policy is saying, though, but if you are if you're an eligible person, you will still remain covered as long as these three other parts are covered. You satisfy them as well. And what are those three other? Those three other parts include the payment of premium, had been insured by the prior carrier. That's all fine. You see, part of what's going on here, which is kind of interesting, is if he was already disabled, and we know he was from Prudential, why is he even paying premiums? Most people wouldn't be paying premiums, but he is here. So then you have to look at, but is he still eligible? because the payment of premiums alone doesn't guarantee coverage. He has to be an eligible person. It says would otherwise qualify as an eligible person.
I think
so what you're doing is you're saying
Counsel, I think we all agree that where we need to look then is whether he is an active full-time employee under the eligible class provision. And we've talked a lot about what full-time means. We haven't so much talked about what active means. But I guess going back to Judge Englehart's question, we have a Sixth Circuit opinion that I think is addressing an identical policy language. And it says these two terms, active and full-time employee, are ambiguous. And so therefore there are multiple ways they could be interpreted, but we need to interpret them in favor of the insured. Now, do you say that the Sixth Circuit was incorrect in that decision so that, I guess, effectively we create a circuit split? If we
Well, there's already been a circuit split on the issue of what active means with the 10th Circuit. And actually the Sixth Circuit, in another case, said active means actually working, a case called Turner versus Safeco. So they've created their own little split within their circuit. And on other issues, this court has disagreed with the Sixth Circuit, whereas this court has said that the term occupation, regular occupation, is unambiguous under de novo review. And the Sixth Circuit has held otherwise, the Second Circuit. So there's already splits. And I think in this case, what you have to do is look at what's reasonable. And is it reasonable to conclude that a person who's not active or actually at work, if I may finish, Your Honor, is not actively at work or actually at work, has not been for 2 months and is not again for a year, can they be considered actually working regularly on a full-time basis? And I think the answer to that is no.
Okay, and I want to be fair to you because we took all the time with the question number one. I want to make sure you have, I'll give you another minute to cover the knee, neck, back argument.
Thank you, Your Honor. I appreciate that. So with the right knee, we know that in 2016, he had both right and left knee replacement, total knee replacement. In June, during the look back period where he had to be treatment free, he's telling a doctor that he has worse pain, especially with rehabbing the knees. So at the very least, he's consulting with a medical specialist for the knee. But that's not the only one. Counsel said that's the only record. It's not. We cite to its ROA 1001 and 1005, where he's telling his physical therapist that his knees are stiff. So he's complaining and consulting about his knees. As to the neck and back, on page 16 of counsel's reply brief, he cites to 10 records. 9 of them are from 2015. They don't prove a disability in 2016. The only other one says there's a history of low back pain and neck pain. History doesn't mean a present issue. So I thank you for your additional time, Your Honor.
Okay, thank you, counsel. We appreciate your argument. And Pam, if you would give Mr. Toledano 6 minutes. So, okay, go ahead.
Thank you, Your Honor. So a couple things here. I wanted to touch on this regular work week requirement in the policy. Full-time is defined as working for a minimum of 30 hours during a person's regular work week. That's true. And what that means is when you're healthy enough to work, you are working a minimum of 30 hours a week. And Michael Miller was working at least 30 hours a week when he was working.
But how do you respond to Mr. Bachrock's concern about, somebody who, let's say, is in the hospital for years or home with an injury for years, and now all of a sudden wants to claim that they are a transferred insured? I mean, is there some sort of time cutoff, and how do we deal with that?
There isn't, as the way the policy is written. I think we have to look at the policy language, and if they wanted to cut it off at some certain time limitation, they could have done so, but they didn't. So I don't know how we can just make one up at this point.
Now, there's this issue of the full-time and all of that. Has there ever been any argument that the fact that for 2 weeks he's sort of 24 hours a day on and 2 weeks he's off, has anybody argued that that's not full-time?
No, Your Honor.
Okay. And that's just the way that's set up for everybody? I mean, so nobody would be full-time, at least no pilot would be full-time?
pilots, they all work the same. And if you look at a record, the administrative record at 882, or record on appeal 882 and 885, those two bait stamps, there's an explanation of how pilots work. And it's 2 weeks on, 2 weeks off, and they're working 24 hours a day when they are working. And we also provided a list of days that he was working, so you can see his schedule. And he was working at least 30 hours a week. So he was working full time. And so I don't think that's an issue in this case.
You're saying averaging out the month, it'd be 30 hours a week.
That's right. And this court looks at this case from a de novo perspective, applying the same standards as the district court. So the court can look at these record documents and find that he was a full-time employee. I don't see a need to remand this matter.
Well, then why didn't the Sixth Circuit decide it if this is just something we can all just look at the record and make a decision?
Yeah, I don't think the evidence was in that particular file, and I'm not sure. I'm not familiar with the record and what was actually in there, but that's what they decided to do in that case, though. But Judge Guidry did not address this issue. I mean, he never addressed the issue of whether Miller was working for a minimum of 30 hours during his regular work week. And it was just not the issue that he was focused on in this case. And so this was never decided by the district court.
Well, why even have the phrase eligible person if we're not going to look at the guy's situation that day or around that day? That's really Mr. Bachrach's bottom line argument, as I understand it, is we're looking at the relevant day, and he hadn't been to work for 2 months at that relevant day, so how's he an eligible person? That's his argument. What's your response?
Right. I mean, he's trying to read an actively at work requirement into the policy that's just not there. If that's what they wanted, they needed to say that he needed to be actively at work on the day that Reliance began insuring the claim, but the policy simply does not say that. And the Sixth Circuit recognized that in Wallace, this court recognized it in Jackson, albeit unpublished. Insureds get the benefit of the doubt when there's an ambiguity in the policy.
The hard part for me is it's pretty clear what is trying to happen here. The employer is trying to switch insurance companies without messing up its employees. And that, I guess, is not always perfectly done. But to me, that if you back up, transfer of insurance coverage is the title, that's what is happening. You've got an employer who decides that Prudential is too expensive or not working out or whatever, gets a better deal with Reliance, wants to move everything over, but wants to kind of keep everybody in the same cubby they were in.
That's exactly right. That's exactly what this is for. And they were very well aware of the issues. That they actually met with one of the Reliance representatives and discussed Michael Miller's specific situation because they didn't want anything to happen to his insurance coverage in the event he came back to work and there was a change of who's going to be responsible for this. And they said everything was going to be fine. And they were really blindsided when the claim was denied based on this pre-existing condition because he thought he had the credit for that, which he should have. Is it appropriate for us to consider that title, transfer of insurance coverage, or should we only consider the other words that we've been talking about, the otherwise, the eligible person, regular, active, full-time? I think you can consider the transfer of insurance coverage. I mean, that's what this was designed to do. All these group disability insurance policies that I've seen have this. They give people credit for the time incurred towards the pre-existing condition limitation credit. And that's what this policy was designed to do. It's a little bit cumbersome, the wording of it, and it's created some issues as we've seen in the Sixth Circuit and now here at the Fifth Circuit. But I see no reason to create a circuit split. I mean, this is literally the exact same facts and the exact same policy language. What about the 10th Circuit, though? Your opponent said we already have a circuit split. It's not exactly the same factual circumstances. I don't believe that was briefed in Reliance's appellee brief. I think he's talking about the Turner case, but I don't remember the specific facts of that, but I know there were some factual differences and there were differences in the way that policy was worded. Okay. Well, your time is up. We'll take a good hard look again at it. We really appreciate both sides' arguments. Very, very well done. Appreciate that very much. The case is now under submission, and we will excuse you from the argument. Thank you, Your Honor.
Thank you, Your Honor.